Let's talk a bit about copyright and how it's different from trademarks. There can be a bit of confusion around this. Sometimes people use the phrase, I need to copyright my brand name. That's not technically true. When you are registering to protect a brand name, that's trademarking, and we talk about that all the time. But when we're worrying about things like copyright, that is making sure that you own the things you are creating, the processes, the procedures, videos like this, any ebooks, any downloadable guides, any software you've created, the source code. All of that is your business's intellectual property, their copyright. You can't register that anywhere. It's not like a trademark. So that means that it's really, really important that you have the right disclaimers and contractual wording included in places that it needs to be. So you'll have seen business name with a little C and a circle and a year. That is showing that someone is asserting their copyright over something. You should always have disclaimers on things, even things like free downloads or website content, to make it very clear if there's ever a dispute that actually you created it first and you own it. Contract wording, whether you're contracting with suppliers or clients, is really, really important. The most important thing to make sure that it's very clear that you own the intellectual property in your product. What you don't want to enter into a situation where you're providing a license for software, for example, to a client, and it turns out you've actually transferred all your ownership rights to that software. You could end up in a bit of a pickle.